just loading. And we're all good to go.
Awesome. Thank you, Noel. Hi, everyone. I hope everyone's having a great afternoon on this wonderful Tuesday. Thank you for attending our criminal expungement clinic. I'm just going to introduce myself really quickly and then pass it over to my wonderful colleague, Ryan, for him to do the same. My name is Lorena Grizzett. I am a staff attorney here at Legal Aid of North Carolina with our expungement team. Ryan.
And my name is Ryan Francis, and I'm the senior paralegal on the expunction team.
Awesome, thank you. So again, we're here for our criminal expungement clinic. So we're just going to go ahead and get started and hopefully inform you all about expungement law in North Carolina. So a little bit about Legal Aid of North Carolina. Generally, we are a statewide nonprofit law firm that provides legal services, free legal services in civil matters to low-income people in order to ensure equal access to justice and to remove legal barriers to economic opportunity. And so our areas of practice include this list here: housing, employment, education, domestic violence, disaster relief, consumer, and expunction as well. And so we have monthly clinics here on Zoom as well that are streamed on Facebook Live for, as this one is today, criminal record expungement, child custody and visitation, employee rights, healthcare power of attorney and living wills, simple divorce, social security disability, and tenant rights. And so you're all here today to learn about criminal record expungement. But if you have any other legal issues that fall into one of those categories, there are monthly clinics so that you can learn more about those as well. And so keep an eye out for those if you're interested in learning more about those. Our website is below, as well as our legal aid helpline. If you're looking for potential assistance with expunction, it gives the line options there. But what I will say is that after this clinic, if you would like to apply for assistance to see if we might be able to take a look to see what might be going on in your specific circumstance, you can go on our website and apply for assistance online. And if you do decide to do that, just reference Facebook Live or the Zoom clinic today so that we know where you're coming from. So that's kind of all the generic information. Just a quick disclaimer that this presentation does not indicate that Legal Aid of North Carolina represents you. This clinic is just to give you all legal information and not advice specific to the facts of your potential case or situation. And so what I will say is that if you have any questions, if you could save them for the end, or you can feel free to put them in the Q&A, but we probably won't address them until the end of the presentation, just because some of those questions might be answered as we go along. And also I would recommend avoiding putting any identifying personal information. And if you have any specific questions about circumstances that you might have going on, I would recommend applying for assistance, because a lot of able to be able to answer any questions that you have, we're likely going to need to know more about what might be going on. And the intent of the clinic is just to explain North Carolina law about expunctions and to help you determine if you might be eligible for expunction of your criminal record.
All right, so I'm going to start us off here with what is an expunction. So in North Carolina, a person's criminal record is made up of both charges and convictions, which means that even if you had a case dismissed or you were found not guilty, the fact you were charged to begin with remains on your record. So an expunction simply clears your record of a charge or conviction. If it's granted, that information is simply gone, and you can truthfully say that the charge or conviction never occurred, within a couple of exceptions. There are some jobs where you would be required to disclose that you had an expunction. For example, a job with uniform services or something that requires a security clearance, or certain federal positions would require you to disclose if you had an expunction. What is eligible for expunction? So the specific offenses that are eligible for expunction in North Carolina law are defined in what we call the expunction statutes, along with the specific requirements for each of those expunctions. And I do mean very specific requirements. In general, there's not a whole lot of wiggle room in expunction law. You're either going to qualify or you won't. There won't be too much of a question. As far as the type of offenses that can be expunged, they include a pretty wide range. You've got dismissed charges, charges in which you are found not guilty or not responsible, certain misdemeanor convictions, and certain felony convictions. And we'll go over that a bit more as the presentation continues. In general, violent offenses are not going to be eligible for expunction unless the offense occurred under the age of 18. However, it's worth noting that what is considered a violent offense does actually change a bit from expunction statute to expunction statute. All right, so the first type of expunction we're going to discuss is also by far the most common one that we see, which is dismissals and acquittals. This allows a person to expunge any and all misdemeanor and felony charges that were ultimately dismissed, where there was a finding of not guilty or not responsible. So a few years ago, the Second Chance Act actually greatly expanded who's eligible to receive this type of expunction, because there used to be a requirement that the person could not have a felony conviction. That is no longer the case. There's also no waiting period, no required hearing, or limit to the number of times a person can be granted this expunction in a lifetime. Also, being granted an expunction of dismissed charges is mandatory, and all the charges in a specific case have been dismissed. And when I say mandatory, that means that if you qualify, the court must grant it. There's no discretion on the judge's part. However, in situations where there were some charges in a case where the result was a conviction and others were dismissed, at that point, a judge ultimately has discretion as to whether or not an expunction is granted. Well, this was a much more exciting section a few weeks ago, but automatic dismissals are no longer a thing in North Carolina for the time being, so that's all I've got on that one. So here's some examples of charges that can be expunged. So in example 1, this person has a simple assault charge. Now, even though simple assault is considered a violent offense, since the charge was dismissed, expunction can be granted. In example 2, we have somebody that was charged with possessing marijuana up to 1/2 ounce and possession of drug paraphernalia on the same date. So ultimately, they're convicted of the possession of drug paraphernalia, but the possession of marijuana charge was dismissed. So they're eligible for expunction of the dismissed charge, but because the other charge resulted in a conviction, whether or not the expunction is ultimately granted would be up to a judge. Then finally, in example 3, this person is charged with felony larceny by an employee, which they are found not guilty. So even though this is a felony level offense, they are eligible for expunction. In addition, since there's no other charge that resulted in a conviction, the expunction is mandatory, even though it is a felony. And I will pass it over to Lorena.
Awesome. Thanks, Ryan. Next slide is about raise the age relief, and this allows the expunction of all misdemeanors and Class H or I felonies that are committed before December 2019 by 16 and 17-year-olds. There is an exception. Motor vehicle offenses and offenses that require sex offender registration are not eligible for expunction via raise the age. Now, some of the requirements, the sentence needs to be completely finished. This can be any active time, probation, post-release supervision, payment of restitution or any civil judgments. There is no barrier to relief, and there's no waiting period, and no limit on the number of convictions or expunctions under this statute. And so as long as the sentence is completely finished, if an individual has a conviction of any misdemeanor or Class H or I felony that isn't one of the 2 exceptions I just mentioned, you should be able to, or they should be able to petition for expunction as soon as that sentence has been complete. And relief is mandatory. And so as Ryan just mentioned previously, that means that there is should be no discretion with the judge as to whether to grant it. Mandatory relief means that if it is petitioned to be expunged and all of those things are satisfied, that it should be. So other convictions under the age of 18, this allows the expunction of a single misdemeanor conviction that was committed before the age of 18. This requires that the individual have no prior misdemeanor or felony convictions and no other misdemeanor or felony convictions within a 2-year waiting period, other than any kind of minor traffic violations. Again, this also requires that the individual has fully completed their sentence, and this includes paying any court costs or fees associated with that conviction, that misdemeanor conviction. And so Ryan, I might call you in to help me a little bit with this if you want to go through them.
Let's see. So, all right. So example 1 here, we've got a 16-year-old receiving 5 felony larceny by employee charges for which they were convicted. So they are under the age of 18, and under the under 18 statutes, multiple felony convictions that occur at the same time actually only count as a single conviction. So they are eligible to expunge all of these. In example, well, okay, I guess we have example 1.5 here. In 2017, we have a person who receives convictions for 2 misdemeanor assault on a female charges. The sentence is completed in 2018. So it has been more than 2 years since the completion of the sentence. And because these assaults were committed under the age of 18, they are still eligible to be expunged, even though they are considered violent offenses. All right, let's see. Example 2. In January 2020, a 17-year-old receives a conviction for misdemeanor simple assault. I have a feeling that when we made this slide, the purpose of example 2 was to say that they were not eligible for expunction yet, but I did not notice this problem. They would currently be eligible for it. So if we pretend that this occurred in January 2022, then they would not be eligible for expunction for 2 years. Sorry about that, missed that one. All right, so we're going to talk a bit now about expunction of non-violent convictions, and these are adult convictions, so over the age of 18. So there are broadly 4 different types of expunction for adult non-violent convictions, which are single non-violent misdemeanor conviction, multiple non-violent misdemeanor convictions, single non-violent felony conviction, and multiple non-violent felony convictions. So we're going to go through each of these one by one here. So first of all, for single misdemeanor conviction, as the name would imply, this allows you to expunge a single non-violent misdemeanor conviction that occurred at any age. If there are multiple non-violent misdemeanor convictions that occurred in the same court session, or you can think of it as the same day, then they can be treated as a single conviction for the purposes of this expunsion. So to qualify, a person needs to have no other felony or misdemeanor conviction on their record other than traffic offenses. And I should mention here that traffic offenses are any misdemeanor offense that occurred under Chapter 20, just to be very specific there. Second requirement here is that they owe no outstanding money or restitution. 5 years must have passed from the date of conviction or from the completion of their sentence, such as probation, whichever of those dates is later. And for this expunction, relief is mandatory, which again simply means if you meet the requirements, it has to be granted by the court. There is a $175 filing fee to request this expunction, though that fee can be waived, and we'll talk a little bit more about how to waive that later on in the presentation. And I'm very sorry, my cat left me alone for 6 hours, but here he is. All right, so next we've got multiple misdemeanor convictions. Of course, this allows the expunction of any number of misdemeanor convictions as long as more than 7 years have passed from the date of completion of the most recent conviction. There are no offenses that are considered violent on the person's record. And there's no outstanding money or restitution owed. And then again, like the last expunction, there's a $175 filing fee. Taking this back over to you.
Awesome, thanks. So for a single felony conviction, as is stated, it allows for the expunction of one non-violent felony conviction. As Ryan previously mentioned, multiple convictions in the same court session can be counted as a single conviction for the purposes of expunction. Now, this requires 10 years has passed from the date of sentence completion of the last conviction, which, assuming would be the non-violent felony conviction, if that was, the only one on the record. No conviction for anything that is considered violent as defined in statute. Relief is discretionary for this kind of expunction, and so that means that the judge has discretion depending on the facts and circumstances as to whether to grant it. However, they need to state their basis for denying it if that is the case. And there also is a $175 filing fee. So that would need to be paid when the petition is filed. However, like Ryan said, there is an ability to get this waived if that would be a barrier for an individual, and we can explain how you can go about doing that a little bit later. And so for multiple felony convictions, this allows expunction of up to 3 nonviolent felony convictions, not misdemeanor, sorry for that typo. And so this allows for up to 3 nonviolent felony convictions to be expunged. There are quite a few requirements here. Firstly, 20 years needs to have passed from the date of completion of the last conviction. The felony convictions must have occurred within 24 months of each other. And so if an individual has multiple felony nonviolent convictions, however, they don't occur within that 24-month period, they are likely not going to be able to be expunged, at least not all of them. No misdemeanor convictions within 5 years of the petition being filed. And so whenever an individual who might be eligible for expunction under this statute, they must not have had any kind of misdemeanor convictions within 5 years of them petitioning for an expunction. No conviction for anything that is considered violent. Again, relief is discretionary, and there again is the $175 filing fee to be paid if not waived. My lights just turned off on me. There we go. I don't know if you want to take this, Ryan.
I was literally just talking for like a minute. Just muted.
Sorry.
All right, so the way that these examples work is we're going to be adding these to the same criminal record as we go down. So if we start at example 1 here, we have somebody who has a conviction for misdemeanor possession of drug paraphernalia that occurred in 2005. So this can be expunged because the charge is non-violent and it has been over 5 years since the date of conviction. In example 2, we add in a second conviction for misdemeanor simple worthless check, which occurred in 2007. So both of these convictions can still be expunged because neither is considered violent, and it has been over 7 years since the date of completion. Once we get to example 3 here, things are a little more complicated. So now we're adding 2 felony larceny by employee convictions to this person's record. Because both of these convictions occurred in the same court session, we're able to count them as a single felony conviction for expunction purposes. So expunction of these felonies can be granted because it's been over 10 years since the date of conviction, the offenses are non-violent, and none of the misdemeanor convictions occurred within the last 5 years. So they could still get their entire record expunged. So moving to example 4, we are adding in an additional felony larceny by employee conviction, this one occurring in 2012. So this person would still be eligible for expunction because they've got 3 or less felony convictions. None of the convictions are considered violent, and it's been over 20 years since the date of conviction. So as of example 4, can still wipe out the entire criminal record. Then finally, in example 5, we add in a misdemeanor simple assault conviction, which occurred in 2013. At this point, this person is not eligible for any type of expunction because they have a conviction for an offense that is considered violent. All right, so let's look a little bit at the process of getting an expunction. So the first step is to determine exactly what type of relief a person is eligible for. So in order to do this, we need a complete copy of their criminal record. There's a couple different ways you can get criminal records in North Carolina. They can be obtained through the clerk of court's office in each county, through a record request sent to the SBI, or from publicly available terminals in every courthouse through a system called Cypress. So once the type of expunction that the person's eligible for has been determined, North Carolina uses a petition process in order to request the actual expunction. Each type of expunction has its own specific petition that would need to be completed. The petitions are available online through the NC Courts website. Many types of expunctions will also have additional documentation that needs to be submitted along with the petition, such as a witness affidavit of good character. Once the petition is filled out, it needs to be filed at the clerk of court's office in the county in which the offenses that are being expunged occurred. So each county has their own rules for how to actually go about filing the petitions, serving the DAs, all the steps of the process. So anytime you're filing for an expunction, it is highly recommended that you first contact the relevant clerk of court's office to make sure you are following whatever their local procedures are. Now, if you have a situation where you're eligible for expunction of convictions in multiple counties, all of those petitions need to be filed within 120 days of each other. In general, once you've filed the petitions for an expunction, it takes about 3 to 4 months to be granted. And then once notice is received that the expunction was granted, we always tell people it is a good idea to actually do another record search on themselves just to verify that the expunction was properly carried out and the charges are no longer on there. Back over to you.
Awesome. So this slide is going to talk about how what kind of filing fees there are and how an individual might be able to waive any of those filing fees that might be applicable depending on the petition that they would need to file for their expunction. And so a petition to expunge any dismissed or not guilty or not responsible charges, there is no filing fee to do that. And so if that is the petition that an individual needs to file, there shouldn't be any filing fee associated with that. Expunction of all other charges and such as plea dismissals, there is a filing fee of $175. And as we just went through, all of those other ones that also require that $175 filing fee. It can be waived by completing what is known as a G106 form. This is just a petition to proceed as indigent. And essentially this form needs to be filled out, signed in front of a notary and filed. And that has the ability to waive that $175 fee for that individual if it is a barrier for them in order to be able to file their expunction. Access to expunged records. So even if an expunction is granted, prosecutors may actually access them, for example, in sentence calculations. So if that individual might find themselves in a predicament in the future where that might be an issue, prosecutors may have the ability to look at any expunged files in terms of determining that sentence calculation. Also has the ability to do that when looking at someone's habitual offender status as well. Even with dismissals, arresting agencies may actually maintain these charges for investigative records and law enforcement access. They have access to expunged record for employment or certification purposes. And so they might be able to take a look at any expunged files as well for that kind of purpose.
And that's for internal hiring. So, you know, if you wanted to be a
right,
they'd be able to check your expunged record.
So certificates of relief are not an expunction, but it can provide individuals who may not be eligible for expunction of some of their charges, some kind of relief in terms of different circumstantial issues within life in general. And so this can provide significant relief to somebody who isn't eligible for an expunction, whether that's now or ever, can help, can provide significant relief, including employer protection from negligent hiring liability, landlord protection for negligent leasing liability. It can override automatic exclusions and can allow opportunity for discretion. And it is also viewed favorably in discretionary decisions. And so having a certificate relief should be viewed favorably when there is a decision that someone might have discretion in making. And Ryan can add on to that for any other kind of comments, clarification.
Yeah, like for example, in the last couple of years, we've had a few people that were trying to become certified nursing assistants, and their records were a barrier to getting the certification. Certificates of relief essentially give the certification board the leeway to grant a CNA, even if somebody has a record that would normally bar them from it. So that's definitely a big one.
So just so, oh, sorry, go ahead.
I mentioned this once really briefly, but it's worth pointing out again. We've got 100 different counties in North Carolina, and the way they handle expunction petitions is going to be slightly different in all of them. So again, anytime you're doing anything with an expunction petition, it's always good to talk to the clerk's office first so that your petition doesn't get held up in some sort of administrative limbo. Sorry, go ahead. That was all.
No, that was pretty much all I wanted to say too. Just if an individual is looking to file an expunction, I would just recommend calling, like Ryan said, each clerk's office, just so that anything that individual might need to know before going ahead with the process, they're aware of, so that they can minimize any kind of potential hiccups in terms of getting things filed, timelines, being made aware of notices of any potential hearings that might be required, things like that.
There are our contact information again. I believe we're now ready for some questions.
I can kind of read them, and then we can kind of just go from there, if that makes sense. With you, Ryan. Okay, awesome. So first one I have here in the Q&A is, I applied for assistance for expungement about 4 months ago. Is the wait list long?
The answer to that is yes, but we've had a lot of staff changes on the expunction team, in addition to the law having changed twice this year. So we've had a lot of administrative challenges on our end, but we're thinking we have it sorted at this point, and things should start moving much faster now. So hopefully the wait list will not take too long to get through at this point.
Awesome. And then another one that's pretty much the same, or I think the answer is the same, is that someone has tried calling and applying online, says not taking any new expunction cases until 2020.
Until actually this week. So as of now, you can call.
Yes, and you can also, like I mentioned at the beginning, if you apply online, if you want to put, if you're watching this on Facebook Live, or the Zoom clinic for this day, August 2nd, so that we can kind of know where you reached out to us from, you can do that as well. And online, it does specify the hours for both the helpline and the online intake, so that you are aware of when you would be able to, essentially reach out for services within that time frame. Awesome. Next one I see says, my charges are from 2018 misdemeanor simple results. Assuming that was a typo, I don't want to assume I know what that means, but essentially they're asking if they would qualify. I'm going to assume results might mean assault, but I don't know for certain. But hypothetically, that is what it could mean.
If you mean that you had you were charged, but the charges were ultimately dismissed, then yes, you can expunge a simple assault dismissal. If it was a conviction, unless you were under the age of 18 when the offense occurred, then it would not be eligible for expunction.
Awesome. Is misdemeanor larceny and felony breaking and entering eligible? Again, this would probably be determined on whether they were convictions or dismissals. If they were dismissals, they should be. But Ryan.
Breaking and entering is actually a really weird one under the current law. So we would actually have to look at the rest of your record to figure that one out. That's like a specific offense that the legislature like calls out in the statutes, and they're always messing around with what it's considered. So we would actually have to look at somebody's record to figure that out for them. On its own, a misdemeanor larceny is eligible for expunction because it's not considered a violent offense.
And as Ryan briefly just insinuated, if you have any specific instances, again, a lot of times it's going to be helpful to look at somebody's comprehensive record to be able to make that determination. So again, the default is apply for services, and hopefully if you're eligible for our services, someone might be able to take a look to be able to kind of see what the specific facts and circumstances are that are going on, to be able to determine an individual's eligibility.
Yeah, I guess I could expand slightly without getting too specific on it. Like with breaking and entering, there's certain situations and certain ways that it's charged where it's considered violent and other ways that it's not. So that's the main problem. We would have to look at it more specifically.
Awesome. How can someone get their gun rights restored?
That process doesn't have anything to do with expunction. I'm not sure because legal aid doesn't handle gun right restoration cases. That would be a good thing to ask a defense attorney about. Actually, we have up on the screen here the lawyer referral line. That's a service provided by, is it provided by the state? I'm not sure if it's a state-run thing, but it's like a low referral service. Sorry, go ahead.
So I think it might be like, I think the top number, I'm assuming because the second one says outside of North Carolina, that the top one is for inside of North Carolina. That's going to be my assumption, but.
It sounds right to me. Yeah, I would give them a call because as it says there, they only charge $50 for a 30-minute consultation. So I'm sure that to the attorneys and law firms that handle gun right restoration cases, I'm sure that they can tell you all you need to know about it within that 30 minutes.
Someone asked, how will new law that went into effect 660 affect expungement?
Well, the big thing that law did was it removed the automatic expunction. I don't know the specifics of what the problem was with the automatic expunctions, but there was some sort of administrative problem on the state's end having to do with like the DMV, I think, is what I heard. So they did those for the time being. We'll see if automatic expunctions come back. The other big change was when we mentioned earlier in the presentation, if you had to file a petition in multiple counties, you had 120 days. A couple of weeks ago, it was a 30-day time limit. So the change in the law increased that to 120, which is very good. Those are the two big ones. I'm not sure the other changes off the top of my head.
Yeah, I think those are two of the, I think, most impactful ones in terms of expunctions, I think, too. Is there a limit to how many expunctions you can get?
That all depends on the type of expunction. For dismissals, like not guilty, not responsibles, there's no limit. And there's no waiting period. So the second you walk out of court, you can just file for expunction of dismissed charges. A lot of I'll say most of the conviction expunctions are a one-time thing. You get one shot at it in a lifetime. Although the under 18 ones are a little different. You can potentially get more than one of the under 18 ones.
Someone, I think this is just a clarifying question. asking it's 10 years after the felony before expungement. That would be 10 years if it's a single non-violent felony conviction looking to be expunged. If it's up to 3 within that 24-month time period, that's where it increases to the 20 years after the last conviction. Correct me if I'm wrong, Ryan.
No, that's right.
Awesome. Again, someone is just inquiring as to how to reach out for possible assistance. I think the best way right now is to try to apply online, but you can feel free to call the helpline, and then the select options for expunction are right there on the screen. And you can go ahead and do that if you'd like to explore possibility of legal aid assistance.
Yeah, like I mentioned earlier, the helpline is open again as of this week, so it's been closed for a little while.
Okay. Someone asks, I'm not sure if this is a question or a statement. Someone's nursing license was revoked in 2016. Just finished their MBA in business intelligence and data analysis, but the issue was on the global watch in the background check.
I'm not sure I know what the question
Yeah,
is.
yeah, me either. I guess if someone is hypothetically worried about anything that might have the reason for something being revoked being their criminal record, and you're looking to see whether you might be eligible for an expunction of whatever might be on there. Again, not to sound like a broken record, but I would just recommend reaching out, applying for our services, and if you're eligible, hopefully someone could take a look to be able to see what might all be going on there. I think that would be my answer to that statement, I guess.
I put one from Facebook in the chat. Since I can't do the Q&A, I was denied a job. Yeah.
Thank you. I see that. Sorry, I am looking. I'm just looking at the Q&A box right now, but
No
I'll
problem.
definitely do that.
Yep.
I appreciate you pointing it out, Nala. Where am I at? Question is, someone has not been in any trouble since 2003. They have, I'm assuming, hypothetically, a felony charge for a Schedule II substance, crack cocaine. Would that be eligible?
So if that's the only, well, if it's a charge, yes. Like if it was dismissed, you could get it expunged immediately. If it's a conviction, we've had questions about both of the confusing charges actually, because like breaking and entering, cocaine is a difficult one to say without looking at your record, because there are certain ways that a cocaine possession could be charged that makes it ineligible, but there's other ways that it could be eligible. So we would have to look at the record to figure out exactly how it was charged.
I'll go to the question from Facebook. Someone says they were denied a job opportunity because of a contempt charge by a judge for their cell phone going off during court. How do they begin the process of potentially getting that expunged?
Well, if the charge was dismissed, you're eligible to get it expunged immediately. So that would be a good one to give us a call.
Someone asked they had a charge of assault that was dropped to a misdemeanor. Individual states that they paid the fees, but the county that occurred in says that did not happen and that they did not pay the fees and it happened in 2013. What kind of course of action should they pursue?
So I'm not 100% sure on that one. You would probably want to talk to a defense attorney. So at legal aid, we do civil law. Expunction as far as we go into the criminal realm. So that's the kind of thing you would want to speak to a criminal defense attorney over. Again, I would call the lawyer referral service number that's up on the screen here and talk to an attorney because they should be able to tell you all you need to know about that within 30 minutes.
Someone states their charges were for felony drug possession. In 1995, they were below the age of 18, 15, and 16. Would they qualify for raise the age? I would say so.
What was the date again?
1995, they were 15 or 16 at the time.
Yeah, that would be a good raise the age one.
Okay. Someone said, so any conviction that is nonviolent has the ability to be expunged.
So any conviction that is nonviolent can be expunged. Yes, depending on what else is on the record. So just because an offense by itself is able to be expunged doesn't necessarily mean that you would qualify for expunction. It depends on the totality of your record. So that's, to answer very specific questions, we would have to be looking at your criminal record.
Okay. I'm about to show myself because I don't know Roman numerals. But someone says, is convicted schedule VI, Ryan, I don't know what that number is. Simple possession, July 2018, eligible. I don't know if that made any sense to you, but.
Schedule 6 is probably marijuana. So in 2018, if that is the only thing that was on a person's record was one possession of marijuana conviction from 2018, then they would be eligible for expunction 5 years after the completion of their sentence. So 5 years after the date of conviction if they weren't given like probation.
Mm-hmm. Okay. And that was just me showing that I don't know Roman numerals. So I appreciate that. Someone, I'm assuming, is asking about a gun charge and possession of weed and whether that is something that might be eligible for expunction.
Very possibly. That would be one where we'd have to look at the record.
Mm-hmm. Okay.
I can say for sure not all gun charges are considered to be violent offenses. So you would want somebody to look at your full record.
Someone says they have 4 charges that are not violent crimes, 2 larceny and common law forgery. Could legal aid help with that?
Yeah, so again, if by charges you mean all of those are dismissed, then yeah, absolutely we would be able to help you get those expunged. If some of those are convictions, again, we would have to look at the record more specifically. And we can't give like legal advice that specific over a Facebook Live.
Mm-hmm.
So that would be give us a call and we'll look at your record situation.
Someone asked where the forms, I'm assuming like the petitions, indigency forms can be found. I believe that's on the AOC website, Ryan, am I correct? Maybe?
Yeah, if you go to like nccourts.org, there's a one of the tabs you could go to is a form tab and you can search for the expunction petition.
Awesome. And another one says that they know we answered the question about a larceny and a felony breaking, entering. Does the same approach apply to a misdemeanor breaking and entering and a misdemeanor larceny? And separately, what kind of information would someone need to gather before reaching out and talking to someone at legal aid?
So you wouldn't need to gather any information before, if you called us to become a client, you wouldn't need to gather any like of your own criminal record info beforehand. That's one of the things that we do is we do the criminal record search, and then we call our clients and we talk through it with them to make sure we got everything. Because doing criminal record searches in North Carolina is kind of more of an art than a science. Doing the searches is, especially when you have people with like very similar names, it can be very difficult to distinguish which charges are yours necessarily. So we pull the records, then we go through it with our clients and make sure we've got everything, and then we can analyze it and see what they're eligible for. As far as the misdemeanor B&E versus felony, I would definitely call us. I don't want to say for sure misdemeanor B&E is eligible, but I believe it was changed in the law at one of these last couple times that it was. I would call us so we can check.
I think the default is feel free to reach out to us, and we might be able to look into it further for anyone to see what the eligibility might be and anything like that. Someone's asking, is it possible to get a DWI or driving after consumption charge expunged for someone who was under the age of 21? I'm assuming when it happened, etc.
If it is a dismissed charge, then yes. But DWI convictions are special. The legislature has specifically stated that they cannot be expunged under any condition.
Awesome.
I guess I should also mention a DWI conviction also doesn't bar you from expunction of other things. So essentially you can look at it as a DWI cannot be expunged, but it also doesn't count when you're looking at whether you're eligible to expunge anything else on your record. I don't know why they pulled that out specifically and made it special, but they did.
What might be the best way to approach having 2 misdemeanor charges in Rowan County and 2 in New Hanover County? If legal aid can help, do I need to apply in both counties?
No, since we are a statewide law firm, you only need to apply at the helpline, which is the number that we have up there. Again, it's a little different from county to county, but ideally what you would do in that situation is you would file by mail in both counties, but you may have to actually like go to the clerk's office and drop off the petition. Now for dismissed charges, there's no like, you have to have all the petitions filed within 120 days rule. So you could literally just file in one county and then when you got around to it, file in another county. But for convictions, you do have to do them all within that time.
And the time, if you have multiple convictions that you're wanting to get expunged in different counties, that 120-day timeline starts on the first day that you file that first petition. So the day you file the first conviction petition in one of the counties, that's when that 120 days starts for the individual to then go ahead and get all of the rest of them filed in the relevant counties. Is sale and delivery eligible?
It'll depend on the drug.
Depends on,
interestingly enough.
it depends.
And even within, you know, well, I mentioned this earlier, but even within like cocaine, depending on the way that they charged it, it may or may not be eligible. So anything in like chapter 90, the drug offenses, that's worth having somebody look at your record to figure out.
What factors go into determining eligibility for expungement with legal aid?
So we actually have employees called intake specialists whose job is to determine if somebody's financially eligible for legal aid. It's a very complicated process. I have no idea what exactly qualifies somebody for legal aid. But if you call the helpline, our intake specialist will talk to you about, you know, how much money you make at your current job, any sort of government benefits you get, and then all that goes into a calculator to determine if you're eligible for legal aid. I should mention it doesn't take as long as that description has made it sound. It's usually like a 10-minute phone call to determine your eligibility.
Someone is asking, what about a CDV charge from over 20 years ago and whether that might be eligible? I'm not sure what a CDV charge is, but Ryan, you might know.
Sure, either. Could you be more specific with what the acronym is? It's gonna be one of those things where they type it out and we feel dumb.
Probably. Yeah, we just don't want to be incorrect. So hopefully if you ask that question and you're still on, if you want to just add a little clarification, hopefully we can answer that question. Somebody's saying that the majority of their record is traffic, but they have some misdemeanor convictions, not sure if they would be eligible. Again, I would hate being like, we'd want to look at your whole record, but that is generally, I think, the default in being able to determine what your eligibility might be. Also depends on what those misdemeanor convictions are as well.
I will say traffic offenses don't in any way impact your eligibility, so it'll just be up to what the misdemeanors were and when they occurred.
Is there a list of charges that are eligible when someone is looking to complete the expungement petitions on their own, per se?
Not that I am aware of.
I don't think so either. Okay, I've gotten some clarification on the CBD. It stands for criminal domestic, I'm assuming domestic violence charge. They're asking if a criminal domestic violence charge that required probation over 20 years ago, eligible for expungement. I'm assuming 20 years ago. That's what the first question said.
So if it was dismissed, like if it was some sort of a prosecution agreement and it was dismissed with the requirement that you have probation, that would be eligible. I don't know off the top of my head whether or not domestic violence, I know this sounds stupid, but I don't know off the top of my head domestic violence is considered a violent offense. So if it was a conviction, we would have to look into it a little further.
Okay, somebody says their convictions, I'm assuming they mean over 10 years ago. Are they still within that 120-day time limit? It's obviously past that time. Okay. I didn't mean to, go ahead. I didn't mean to confuse anybody.
No, I think I did the same thing. So the 120-day time limit we're referring to is just when you're filing. So if you're eligible for expunction of like 3 different convictions in like Wake County, Durham County, New Hanover County, once you file, say, the petition in Wake County, you then have 120 days to file the other 2. Otherwise, you can't add them in later. That's what that 120-day limit is for. That doesn't have anything to do with your eligibility for expunction.
Awesome. That's all the questions that I see in the Q&A. I'm not sure if now you're still monitoring the Facebook and whether there are any ones that popped up there. But that's all the questions that I see right now.
Awesome.
Yeah, 1 minute. It's just working, but I'll go back to Facebook.
You're fine. I appreciate it now. I didn't mean to call you out.
No, you're good. Let me mute my thing because otherwise it'll start.
I feel like this is the only area of law where you
No, we're good. Patrick's just messing with us on Facebook.
No.
Okay.
Patrick's
awesome.
just what?
I said thanks.
Yeah.
What were you saying?
I was saying Patrick's just messing with us. Patrick was like, I have a question.
Nice.
I'll answer it tomorrow. All right, well, thank you very much for attending, everyone. I hope this was helpful. And
Yes.
like I said, if you have any inkling that you may be eligible for an expunction, give us a call. We'll take a look at your record and go from there.
Awesome. Thanks, everyone. Hope you have a great rest of your day and a great week. And thanks, Ryan, Niall, and Gabby, for helping.
Yeah, thanks Lorena and Ryan for presenting, and thank you everyone for joining. Have a great week.